All right, court, we're on the record. All right, defense has filed an application for writ of habeas corpus seeking.
Right from the opening seconds, we're dropped into a critical moment. The defense is asking the court to reduce a $200,000 bond, arguing that the defendant, Ivan Monica Petz, simply cannot afford release while awaiting trial. But here's the twist that instantly raises the stakes. This case involves the death of a child. And when a child's death enters the courtroom, every legal decision becomes heavier, emotionally and legally. Let's unpack what's happening. A writ of habeas corpus motion in this context is basically the defense saying, this bond is excessive and our client deserves a chance to fight the case from outside jail. They're arguing financial hardship, medical vulnerability, and jail safety concerns after alleged attacks inside custody. But courts weigh two major things here: the defendant's rights and community safety. And when allegations involve harm to a minor, judges become extremely cautious. Even if someone hasn't been convicted yet, the court must ask, if released, could this person pose a danger? And here's a question for you watching. Should inability to pay bond ever be enough to release someone when the charges involve a child's death? Or does public safety outweigh financial hardship? Stick with us, because this hearing is about to reveal emotional, legal, and moral questions that get even more intense as the case unfolds.
Bail, she has bail. You're seeking a reduction?
Correct.
All right. State, are you prepared to proceed?
Yes, Your Honor. It is the defense's motion, but the state.
No, I mean, if you're just
yes.
ready to proceed.
Yes, Judge.
All right. So defense, the bond is set at $200,000.
Yes, Your Honor.
You may proceed. Everyone, I need you to whisper. All right. Defense, do you have any witnesses?
No, Judge, we've filed and attached an affidavit from Ms. Perez, showing it to the state, where she obviously in U.S. custody, so she's unable to make bond. Her family and friends are either unwilling or unable to help with her bond. Her assets, because she's been in custody for so long, she doesn't have any. She doesn't have any money. She doesn't have a house. She doesn't have a vehicle. And in addition to that, we've outlined two different incidents that happened at the Bexar County Jail, where she's been attacked two different times. And the most recent one led her to be in a wheelchair and the condition that she's in. She does receive medication from the jail, but they've told her that there's no physical treatment available for her at the jail. And so we're asking, in addition to just unable to afford the bond for medical purposes as well, to be able to get out, seek medical treatment. She would have a place to stay here in San Antonio, Texas. She could be on full monitor house, full GPS, because
This moment is crucial because the defense shifts from financial hardship to something even more urgent: medical necessity. They argue that jail cannot provide the treatment she needs after being attacked twice in custody, leaving her in a wheelchair. Now, legally speaking, medical conditions can influence bail decisions. Courts must ensure detainees are safe and receive adequate care. But here's the complication: even serious medical needs don't automatically override public safety concerns. Notice the defense offering strict conditions: GPS monitoring, house arrest, no access to children, and a child-free residence. They're basically saying, Judge, lock her down at home instead of jail. But this raises a bigger debate in the justice system. Should defendants with severe health concerns remain incarcerated if alternatives exist? Or does the severity of the alleged crime outweigh compassionate considerations? And think about this: if someone accused in such a serious case lived next door to you under house arrest, would you feel safe? The emotional and legal tension here is only rising, and the prosecution is about to make their counter-argument crystal clear.
Case involves allegations where someone's under 18. She would be able to stay at a place that has no children and no access to children, if the court would feel more comfortable with that. So we feel that with those conditions in place, the community would be safe, and she would, with the GPS condition as well, there would be no worry about her appearing for court dates.
All right, state,
Your Honor, as you know, this case involves the death of a child.
All right, everyone, please whisper.
A pretty horrific death of a child. And at this time, they are allegations, but due to the serious nature, we feel that $200,000 is appropriate. But that if the court is willing to lower them, then obviously full conditions. But for something involving something like this, I feel like anything lower than 150 even would be just way too low. It also is a little concerning that no one's willing to help her, because then how is she going to be supported in the community? That's just concerning to the state, Your Honor.
Well, just to clear it up, it's not no one, it's just people, unfortunately, the people that are willing to help are just unable to do so financially. So.
All right, the court is going to deny the motion. And the court has had no evidence on what amount of bond that she is able to make. So at this time, the court will deny the motion.
And there it is. The judge denies the motion to reduce bond. That means Ivan Petz remains in jail while awaiting trial, unable to post the $200,000 bond. The judge makes an important legal point. There wasn't enough evidence presented about what amount she could realistically pay. Courts need proof. Bank records, family financial commitments, or concrete evidence showing a lower bond would still ensure court appearance. Another key factor? The prosecution subtly questioned her support system. If no one can financially help, how stable would life outside jail really be? Judge Boyd also addresses safety concerns, noting Petz is already in protective custody, which is designed to keep vulnerable inmates safer from harm. So here's a tough question. Is jail the safer option in some situations, even when inmates face threats inside? At this point, though, the story shifts gears, because what follows isn't just about bail anymore. We're about to move into plea discussions and the deeper facts behind this heartbreaking case.
And counsel, if there's an issue, is your client in protective custody?
Yes, Your Honor, now.
All right, if there's an issue at the jail with her safety, just let the court know. But my understanding, she is in protective custody. Beyond that, that's all I can do. And counsel, I've always found them to be receptive if there's an issue with danger. Okay.
Yes, Your Honor.
All right, thank you.
Thank you.
2022 CR 11873, State of Texas versus Yvonne Monica Perez. Can I have parties announced for the record for the state?
Allie Jackson.
Defense.
Matthew Allen.
Are you Miss Perez?
Yes, ma'am. Yes, Your Honor.
Counsel, have you received all the discovery that you revealed with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you understand you're charged with assault intentionally, knowingly of serious bodily injury by omission with a child? Did you understand that's the offense?
Yes, Your Honor.
Range of punishment is 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Now the stakes are laid out in cold, hard legal terms. 5 years to life in prison. Hearing that range spoken aloud is often the moment reality hits defendants hardest. Notice how procedural this sounds. Discovery compliance, plea understanding, competency checks. But this routine process masks something huge. This is where a defendant decides whether to fight at trial or accept a negotiated plea. And here's why plea deals matter. Trials are risky. Jurors can be unpredictable, and sentences after conviction can be harsher than negotiated deals. So, defense attorneys often advise clients to consider certainty over risk. But let's pause here. If you were facing decades in prison, would you gamble on a trial or take a plea deal to reduce uncertainty? Because what comes next isn't just legal mechanics. Emotions explode into the courtroom as the defendant reacts to the gravity of her decision.
Yes, Your
Do
Honor.
you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 18 years in the prison and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State Office State's Exhibit 1.
No objections.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Is there a reason she's crying?
She's just upset.
All right, what are you upset about?
Just situation. I didn't expect this.
What's upsetting you about the situation?
This is where the legal case collides head-on with raw emotion. Petz breaks down, saying she didn't expect the situation to reach this point. And moments like this often divide public opinion. Some viewers see genuine remorse, someone realizing the devastating consequences of their actions. Others see regret not for what happened, but for getting caught or facing punishment. Defense counsel emphasizes her emotional state over months, saying she repeatedly expressed regret and guilt. But here's the difficult truth courts face. Remorse matters emotionally, but sentencing focuses on actions and outcomes, not just feelings. And this raises a hard question. How much weight should remorse carry when the outcome is irreversible? Because at the end of the day, the court must balance sympathy with accountability. And we're about to hear disturbing details about how this tragedy unfolded.
Try to do something kind and just,
It's just I don't know if the court has noticed, every time she's come in, she's been very,
Crying.
very emotional, Your Honor.
I apologize, Your Honor.
No, I'm just asking questions. All right, if we can go off the record. All right, state, are you asking to amend the stipulations?
Yes, Your Honor.
No objections.
All right, and then the court will review states exhibits 1 and attachments with the amended stipulations. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor.
Anyone want to say why should follow this plea bargain agreement?
I can speak briefly on that, Your Honor. I think for the stipulations, so the way that she came about, Ms. Pettis came about to have the child was kind of strange to begin with. She, in my opinion, I think, saw these 2 children that were on the streets. Her and her partner tried to help take them in. And then obviously there was an incident that Ms. Pettis describes a week prior to this where, again, she should have taken the girl in for medical treatment immediately. And then obviously she fell from the stairs.
Let's backtrack a little
Okay.
bit. Because it says in the stipulations that there were 2 people outside of the store. She says she's being a good Samaritan. So she takes them both back to her apartment. And then she tells one of them, I can no longer keep you here. You need to leave. But I'll keep the complainant.
Yes, her and her partner, so her partner ended up, I believe, keeping the younger boy, and she kept the younger girl at the apartment. And then,
And is this younger boy currently alive?
Yes,
Yeah.
Your Honor.
yes,
And where is he?
As CPS has removed him, he leaves with other family.
Okay.
the incident described that is the leads to this tragedy, obviously, Yvonne describes it as she's playing. Obviously, the kid shouldn't be playing on the stairs. We know that. She hits her head and the back. She seems like she's okay as far as checking on her. She's eating, watching
So why would
TV.
she pinching her as a sign of as punishment? Because that's what it says in the steps that she would pinch her.
Yes, Your Honor.
Why?
This exchange is one of the most uncomfortable yet revealing parts of the hearing. The judge digs into details that show repeated questionable decisions, not just one tragic moment, but a pattern of poor judgment. The defendant describes disciplinary actions that left bruises and admits failing to seek medical care immediately after injuries. Even if there was an intent to cause severe harm, neglect and delay in treatment become central issues. And here's what makes the judge visibly frustrated. This situation didn't start with the final incident. There were multiple earlier points where intervention, medical care, or authorities could have changed the outcome. So viewers, ask yourselves, at what point does trying to help someone turn into responsibility for what happens next? Because legally, taking a child into your care carries enormous responsibility, and failing that duty can lead to devastating consequences, even without malicious intent.
It wasn't like I'm pitching her just kind of like a grab, like just
It says it
to
left
prompt her.
bruises.
I'm sorry.
It said it left bruises.
I didn't realize it was gonna leave a bruise. I didn't intentionally do it to like leave that bruise. The little girl, when my daughter was, when
And so I think she's describing as, yes, she again is admitting to that. It doesn't matter whether you think it's gonna leave a bruise or not leave a bruise, I think we would agree. And then as far as her actions, she seemed like she was okay, and then the next morning, obviously, she's not, and then drops her off at the hospital, and then obviously does another, another bad thing, just leaves her and then leaves. She does come back, she does sit down with the police, she does talk to them, tell them everything that's going on and what happened. Obviously, at that point, it's too late, but I can speak to Ms. Perez from the day I've been with her for 20 months or so, from the day I've met her until today. Every time I talk to her, she's upset, and it's not because of so much of her situation, it's because of what happened, and she knows that she did wrong. She knows she wishes she could go back in time and change all of that, and she says that every time I talk to her. And so
Like maybe if somebody is offering you a child, maybe calling the police.
yes, going that far back, it's not one mistake, it's things that happen over and over. And again,
So was the child healthy when she received the child?
I don't,
Was the child healthy when you received the child?
the first one is Joel,
No, I'm talking
Um,
about the child that is deceased.
I don't,
Was that child healthy when you received the child?
healthy in a sense, she was
Healthy in the sense
skinny,
that
she
she
was
had-
skinny,
Did
we
she have
fed
all her
her.
hair?
Did she have all her what? Her
Hair.
hair?
On her head?
Yes, Your Honor, only like patches, like not patches, but like her hair was thin. Her hair wasn't thick, it was thin. Her hair was thin. And she came when I picked her up when Cassandra told me to go, and when we went to go pick her up, she had like a dirty little outfit. I bought her clothes, there's a lot of things that I should have done and I didn't do when she first arrived at our home. I should have taken her to get a welfare check. I should have done, and I didn't. I just was
well,
trying to-
and like Your Honor said,
help.
the initial thing would be to contact authorities to go through the proper channels. I think CPS was contacted prior to
They
this and made contact with Ms. Pettis, so they were aware of the situation, but again,
Aware of what situation?
that the girl was staying with Ms. Pettis. But
Was
again,
that before or after the child
before,
was taken to the hospital?
before,
So Child Protective Services was aware that somebody off the street gave her a child. And she picked up the phone and called Child Protective Services and said,
No,
"I have this child."
no, Ms. Pettis didn't, they contacted her. So
Mm-hmm.
again, I agree with the court, she should have done a lot of different things.
Well,
and
I'm just unpacking things a little bit.
Yes.
So,
The mother has extensive history with CPS and had different children taken away, so I think CPS was checking into the whereabouts of Ronnie and Howell.
all right.
It was that.
So that's how CPS found out that the child was in her care,
Yes.
and CPS did nothing.
Parent.
Okay. CPS workers sometimes, well, many CPS workers are overworked and underpaid, but I'm wondering why would a CPS worker, and this is just a side note, why a CPS worker would leave a child with somebody that a mother just gave to that's a complete stranger. I guess that's something else that needs to be addressed.
Yes, and like I said, the circumstance behind it are to put it, I guess, strange, and that's one of the things that I found strange as well, to, I guess, put it nicely. But
So why am I following this plea?
Your Honor, at this point, the state, after much back and forth, we recommended this plea due to what is actually being charged, and what we can prove. It becomes a question of whether or not we can prove that she did not seek adequate medical attention in terms of she has training as an LVN and attempted to keep an eye on the child at home, and it becomes whether or not we would be able to prove that she failed to do so due to how it is charged, Your Honor. And so at this point, we do feel 18 years for what she's charged with is appropriate.
All right, and does she have a license as an LVN? I'm assuming.
She did in the past.
She did in the past, and then I needed to renew it.
it's
'cause I went-
expired, is that right?
Yes, and
Yes.
then I started going to school to EC. Oh, sorry.
That's okay. It's expired.
This is what the court is going to do. As previously stated, the court is finding you guilty. Court is going to sentence you to 8 years in the prison, give you credit for any time served. There's to be no contact with minors. There's to be,
Judge, did you say 8 or 18?
18. Yeah. Did I say 18?
Okay.
All right, thank you.
It's okay. Matt and I are done
Yes,
this
all right.
morning.
18. All right, 18 years in the prison, credit for any time served. There's to be no contact with minors, and there's to be no employment in the future with minors or vulnerable persons. Is there anything else with regards to sentencing?
Not sentencing, we do have victim impact, Your Honor. Hold on.
All right, we can go off the record. Here's the thing, whether you had your LVN license or not, I saw where you took your dog to the groomers. When a child is sick, you take a child to the doctor.
Yes, Your Honor.
I don't know why. Sometimes people have more love for their animals than they have for little children.
Judge Boyd's closing remarks cut deeper than the sentence itself. Her message isn't just legal, it's moral. She points out a painful contrast. The defendant sought care for a pet while failing to seek immediate care for a vulnerable child. The court ultimately accepts the plea agreement, sentencing Ivan Monica Petz to 18 years in prison, with credit for time served, plus lifetime restrictions preventing her from working with minors or vulnerable persons. This case leaves several difficult lessons. Good intentions don't replace responsibility. Trying to help without proper safeguards can lead to tragic outcomes. And once harm occurs, the legal system focuses not on what someone meant to do, but on what actually happened. So now we turn to you. What do you think justice looks like in a case like this? Was the sentence fair, too harsh, or too lenient? And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.